The following is a pre-recorded broadcast brought to you live for the purpose of live discussion.
Thanks. Be seated. All right. Good afternoon and welcome. This is 25 CR 1509. Excuse me. Commonwealth versus Zach Kilgore, Donnie Stoner, and Ronnie Stoner. Counsel that are here, if you'll identify yourselves, please.
Good afternoon, Judge. Andrew Reinhardt and Morgan Perfumo for the Commonwealth. In the gallery are numerous victims on this case.
Rob Eggers for the defendant, Donnie Stoner.
Greg Sims for the defendant, Ronnie Stoner.
All right. And I assume Mr. Kilgore is still out on warrant. All right. Well, let's go back place and time to last Monday when I think all the parties but Mr. Sims pressured the court to go quickly. And all we really did was briefly discuss it, passed effectively bond decisions to today. In the meantime, I saw at least one motion from you, Mr. Eggert, and I assume, Mr. Sims, did you file an entry of appearance, or do you intend to?
I intend to file an entry of appearance, Your Honor. I'm fresh on this case, and I'm happy to do so.
Okay. And really, I wanted an update from Commonwealth on what's pending anywhere else or anything you've talked about or decided in the absence between last Monday. So, Mr. Reinhardt, you first.
Judge, at this point, I do believe the case is appropriately here in Division 3. As I argued last week, it's a whole new case from what is in Division 7. Does it encompass some of the stuff that's in Division 7? Yes. But this case involves two new defendants, numerous acts over different years that are not charged in the other indictment. That being said, Judge, we asked the grand jury judge to set a bond of $500,000 on the arrest warrant. And that's for several reasons, Judge. First, the danger to the community. As I said last week, both of these defendants are alleged, and a grand jury has indicted them for numerous sexual abuse acts on children at schools over a period of 2 decades. They would get under investigation at one school, go to another one, and continue to offend. So while Mr. Eggert and Mr. Sims are likely to point out that they don't have a criminal record, they have been committing crimes for a long period of time. And so what I'm asking the court to consider is what is an appropriate financial bond for a serial sexual predator here in this case, and that's what we have. And I know the court has had other trials or other cases here with one victim where a bond's been set at $100,000. I think here, both the defendants here, they have private counsel. They both have a significant amount of assets, and I do believe a significant financial bond is appropriate. I also think that they're an inherent flight risk. These are very serious charges. I know, I believe it was Mr. Donnie Stoner was working out of town, out of state at Tennessee for a while. So I do have concerns about flight. I do believe a significant cash bond and $500,000 is appropriate under these circumstances based on the case.
All right, one at a time. Ms. Eggert, you first.
First of all, Judge, I take exception to these kind of serial sexual predator, okay? I mean, if he's speaking to the cameras, fine, but he's not. He's supposedly, anyway, speaking to the court. Just to go back to some basic facts, while they may say he's done this or A, B, C, and D, he has no record. He has no criminal record, zero criminal record. That's just the fact. Second of all, he
And your client, this is Donnie?
Yes, this is Donnie. He lives with his son.
No, I'm asking because I have pretrial service report on him.
And I think there you can see, I don't think there's anything there that would indicate anything of what that the Commonwealth alleged here at all. He works, he supports his son and his
What is he doing now? You say he's working.
He's a truck driver at this point.
Or was? Okay.
Truck driver.
Okay.
And there's just nothing to indicate that he would flee. Zero. In addition, Judge, you don't have to take my word for it. One of the things they did when they did this new indictment, the charges that he already were lodged in Division 7 multiplied. Okay? They
Right.
took those same charges and just said, okay, 10 years and...
Well, which is why I want the Commonwealth to formally respond to your motion to remand it there. I'm not going to make that decision today, but I do want to know procedurally the interplay. I'm going to hold his motion in abeyance, Mr. Reinhardt, and all right, yes, I get it. Commonwealth has allegations, you have defenses.
Yeah,
That's the whole
they
point.
had these allegations, and then when they re-indicted, there are some new allegations. When I say new, they go back to 2005. But they took the ones already in Division 7, repeated them, then divided them up and added, because there was a 10 years age difference. It was a student, I think, who was 16 or 17, actually, almost 18, and said, well, there's 10 years age difference, so multiplied those charges. But the best, Judge, the best evidence that they'll obey your rules is what's happened in the Division 7 case. I went back and looked at the court net there, and Judge, he was originally, a warrant was issued at a district court for his arrest, and we turned ourselves in, July 23. We appeared in district court. We were indicted August 23. We appeared for arraignment.
Right.
The case has been pending since then. We went to court 9/13/23. Then we went 11/15/23, 12/14/23, on HIP the whole time, compliant. Then in December 23, finally released from HIP, but on MCR, compliant. Then we came back in 24, January, March, April, June, July, October. Always here, always obeying the rules. February, March. They never made a 404B motion. They never suggested he was a danger to the community. They never moved to indemn the indictment. In fact, we had a trial date, and it wasn't convenient.
I thought you still had a trial date.
What?
I thought you still have a trial.
It did, but we had a previous one. We had a previous trial date, and it wasn't convenient, I guess, for the victim. We agreed to a continuous, and that's why it is where it is. He's going to do exactly what you tell him to do. He's going to be at home. He's going to either be there at work. He's going to obey the rules. He's going to come to court, because that's what he's been doing for the last 2 years. So I think this bond should be exactly where the court said it. He's here today, knowing what they were trying to do.
How many indicted charges are there in the Division 7 case against this individual?
I think
I mean,
it's
like
somewhere
2 or
around
like...
20.
I think it is up to 20.
Okay.
It is 20.
All right. Let me hear from Mr. Sims.
And Judge, just be clear, those 20 charges all are Class Ds except for one Class C. The new charges are all much more serious.
I looked. There are multiple Class B felonies indicted here. I understand. Mr. Sims.
Your Honor, may it please the court, I would echo the sentiments of Mr. Eggert, and I would also add, it's also significant, Mr. Stoner, my client has essentially no record whatsoever. The failure to appear and bench warrant situation is what I've always considered to be an extremely important factor in setting a bond. The past is an indicator. The past is the indicator of what will happen in the future. In fact, it's the best indicator. And it's not present here. Rather, both these two defendants sit before you. They are on HIP. If they were such a flight risk with all these new charges, why are they here? It would have been a perfect opportunity to cut off this bracelet and run to Mexico if that was their inclination. They are here, and I can speak for Mr. Stoner, for my client, because he adamantly denies the allegations that have been brought and wants to make sure that he addresses those. Not just here for this court, but for the community that the Commonwealth seems to be speaking to in its arguments today as well. So, Judge, with that, and in addition, I would just like to make sure the court understands that Ronnie Stoner lives with his partner, Jamie, for the last 10 years here and is well-rooted in the community and still has work here if the court were to allow him to remain on HIP and allow him work release. Thank you, Your Honor.
All right. I'm going to set the bond the same for both. I'm not sure either one of them have been booked Did they do that when they went to HIP last week? Mr.
Yes.
Sims, for your client especially?
My client has been booked, Your Honor.
All right. Because of the number of charges, what I'm going to do is partially secure the $500,000 to 10% of that, posted to HIP with no releases until we can get the procedural aspects of the case more. And just so, and I'm definitely talking to the lawyers, not the cameras, to remind you all, the purpose of bond is not to punish, it's to...
You're talking 50,000?
Yes.
Because they don't have 50,000, Judge. And these charges go back to
So
2005.
that's my decision. That's the bond.
Please note my objection, Judge, because I think this is a grandstand political move where they've gone back 20 years to put these men in jail. 20 years. They can't post 50,000. They don't have 50,000. They're getting punished before trial, and they're getting punished by bond. They can't possibly make it. On a case where they're back, and he's been going to court for 2 years.
Counsel, I am not grandstanding, but I am listening closely to you. And Mr. Sims, you need to have a seat. That's my decision, and you need to sit quietly. Do you understand? The bond will be $50K, partially secured 10% from the original grand jury warrant. I'll listen in the future to bond requests as the case progresses. I urge you not to grandstand as well. And let's come back in a more calm moment and talk about procedurally what's going to happen next. So,
Well, Judge,
how much...
we don't have a bit of discovery, not one bit of discovery for acts going back 20 years. They'll be laughing and drinking tonight, putting people in jail who come to court, who've never been convicted, who went to court for 2 years and come in on this. It's an abuse of the grand jury process. It's a political indictment. They've had this case for 2 years. I don't believe a word that they've said about new evidence. They've had whatever they've had for 2 years.
Judge, I'm gonna object here because he's making it sound like this is some sort of personal issue that we're taking here. We have had new additional evidence. We have talked to all of these victims that the court can see here.
Gentlemen, I know you both well. You have been here a lot. Calm down. The court has made its decision. That is the bond. I will listen to future motions, but what I will not do is allow anyone to turn this into a circus, including counsel. So
I'm not the one who did that.
you need to sit quietly, Mr. Eggert. How much time do you need to fully at least get initial discovery? Whatever you have, you should be able to do that in short order.
I would say at least 2 weeks.
Oh, yeah. It's,
So
I was thinking more like
30 days.
either right before or right after Labor Day. To make a difference.
I'm out the week of September 1st, but I could do the week when I come back.
Defense counsel, does that make a difference to you? You know your schedules better than I was suggesting either right before or right after Labor Day. It's tomorrow in this August or July the 29th, so I'm giving them a little bit of time to give you a comprehensive discovery load so you can look at it.
Judge, presumably they could get discovery next week if they wanted to. After all, they got $500,000 by walking in ex parte to a judge and saying, give me
Counsel.
$500,000.
I hear you, and I've heard you many times. I'm asking you for scheduling purpose what's convenient for you.
Judge, we make, it's whenever the court wants appropriate. Judge, we would ask for this. The bond is essentially $50,000.
That's correct.
Okay. We would ask permission to post double property if they've got it. It's a lot of property, it'd be family property.
Only if the property's in their name.
They don't have it, but if it's in spouses' names, family members, dad's name.
Not today. I want to see that. All right. How about Wednesday, August 20th? Mr. Eggert, you ostensibly have a homicide trial that week.
We're supposed to be at the prosecutor's conference that week.
Would Wednesday, August 20th, late morning work for you?
Well, like I said, we're supposed to be in Lexington. I can.
Oh. Does it start that day? What about the day
It
before?
starts that day.
What about the day before?
I could do the day before.
I can do the day before. I could do first thing on the 20th as well.
Can you only do first thing in the morning on that day?
No, I mean, I could do Monday or Tuesday.
No, first thing in the morning on Tuesday is always my rocket diagram.
Okay.
I was going to suggest noon to get so the courtroom is open as possible
On the 19th.
on the 19th. Will that work?
Yeah, I mean,
Mr. Sims, will that work?
Noon on the 19th, Your Honor?
Correct.
Yes, that works for the defense schedule. May I, Your Honor?
Yes.
You know, at this point, I know the court's made its decision on bond, and I'm not attempting to argue that point any further. I will note that my client cannot post that, and I don't believe that it would be possible at any point. So we would ask the court to set a trial date for Ronnie Stoner this time.
Not today, but I will when you come back on the 19th, and it'll be roughly a year out. But this case will not lag. I will set a trial date when you come back, and it'll be as soon as I can possibly work it in, and you're ready to try it. So I will assure you of that. For today,
but essentially, you're saying they're going to have to spend a year in jail.
For today, Mr. Eggert, it's cash. I am willing to listen if I can be convinced that the property that's being offered is somehow tied to them in an appropriate way. What I will not allow is third parties or until I can be convinced from a title perspective. So, all right, anything else for today?
If it's a property bond, double, is that $1 million in property because it is a $500,000?
$1 million? I mean, how far are they going to push things here? Seriously, how far? Maybe a $5 million bond. Maybe a $10 million bond.
Violates, he's on the hook for the entire $500,000.
Maybe a bond. How far are they going to push the system? You should read his affidavit, Judge, for $500,000. It's filled with misleading statements. In any event, Judge, $100,000 would be double.
Let me review the statute.
Yes.
You're invited again to sit quietly and stop being disruptive. I hope you understand the seriousness of my tone and my long history with your behavior and antics. Sit quietly, Mr. Eggert, please.
I am.
Anything else for today?
No, Judge.
So on the 19th, be prepared, bring your calendars. I'm going to set this case for trial.
We will.
And I'm willing to listen on property on that date and time as well. For today, they're going to have to go with us, as you know. Anything else? And I would like the Commonwealth to comment in writing on the transfer to 7. If that's your choice and you wanted to do that and carve out one person, that's what we would do. I'm happy to do that,
Well,
especially with a trial date.
I want to make sure that Mr. Eggert is still on that motion that he wants it to go to 7.
Judge, he's not going to ask that go to 7 now because he got the bond he wants.
No.
So he'll, I mean.
Well, when did you file the motion?
I filed it before arraignment. I hadn't even seen the indictment.
I apologize. I thought you filed it after I saw you last Monday.
No, I filed it before
Okay,
arraignment.
okay.
Yeah.
Okay, then I misunderstood.
Before I even saw the indictment.
I misunderstood. So
is
you're
that-
no longer.
Is that still their motion? I don't.
Well, I haven't even seen the discovery yet, so it's kind of hard for me to, yeah.
It'd be helpful if you would listen when I'm talking.
Right.
Let me hold that motion in abeyance.
That's
I
fine.
still want you to say something with regard, if that's your choice. The custom of the Jefferson Circuit Court is all indictments for an individual go to the oldest pending indictment, and that is not here. And especially with the recusal, the reallotment, everybody seems to know way more about this situation in this case than I do. I know nothing, and won't seek to know until I see the discovery and other aspects of the case. So, but I'm willing to listen. But if that's your choice, of course, I'd be happy to do that. All right, anything else we need to talk about today?
No.
All right, well then.
May I approach on an unrelated issue?
Not today.
Well, it's
What is
regarding
it?
personal property watch and things that I may take to his wife. I was at one
Why
day.
don't you can hand it to him.
Thank you.
Yeah. All right, anything else? All right, see you on the 19th. I'm not sure, honestly.
If you do nothing else,
If you do nothing else.
Do nothing else.
If you 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 do nothing else.
Stay live.